Assalamualaikum. My name is Nur Amalin Husna, and for this case law presentation, I will present on the case of Brown and Pourau. So the parties involved in this case there are four, which is Sophie Douglas, Emma Pourau, Mark Pourau, and Jenny Brown. So the one who brought this case is the plaintiffs, which is Benny Brown and her siblings, and the defendant here is Mark Pourau. Okay, so for the first involved person is Sophie Douglas. She is the owner of the homestead. She made a will and leaving it to the daughter Emma. And the second person here is Emma Pourau. She is the sole beneficiary of Sophie's will, and she died and passed the land to her son, which is Mark Pourau. So Mark Pourau here is the Emma's son, who is the defendant in this case. So this case is about Sophie Douglas, who made a will in 1977, leaving the homestead property to her eldest daughter, Emma Pourau. The will was challenged by other family members who claimed that Sophie lacked testamentary capacity or created a secret trust for the family. Emma attempted to apply for a Papa Kaya order to declare the land as a communal property for the family, but was unsuccessful in the Maori Land Court. Emma Pourau then died in 1986 and left the property to her son, Mark Pourau. Mark intended to sell the property to Wangamata Golf Club, but was opposed by the plaintiffs, who sought to recall the grant of probate of Sophie's will. They claimed Sophie intended to create a trust for the whole family. So there are two issues arises in this case. And for the first issue is regarding the testamentary capacity, which is whether Sophie Douglas had the mental ability to make a valid will when she left her property to her eldest daughter Emma. And for the second issue arise is whether Sophie Douglas had created a binding obligation on Emma to hold the property in trust for the benefit of the rest of the family, based on her oral expressions of her wishes. So the court decided in this case that the claims were rejected. The validity of the will was upheld because there is no secret trust. Therefore, Emma or Mark is the lawful owner of the property according to the will. On the first part of the judgment, it is about testamentary capacity, whereby the court declare that a testator has the mental need to have a mental ability to make a valid will when there is an understanding of the nature and effect of the will, the extent of the property, and the claims of the beneficiaries. So in this case, the evidence suggests that she did, despite her deteriorating vision. Several witnesses testified that she was not blind and could see well enough to read and write. The solicitor who drafted the will also stated that he explained the will in full to her and that she understood it. Furthermore, there is no indication that she intended to create any secret trust, which would require clear and convincing evidence of communication and acceptance. On the second part of the judgment, under the secret trust, there are three requirements to be fulfilled in secret trust, which include intention, communication, and acquiescence. Okay, for the intention, the testator intends the gift to not be used how the beneficiary desires, but how the testator desires. And for the communication, the testator tells the beneficiary of their intention, and for the acquiescence, the beneficiary accepts request through express or implied promise. And the standard of proof of this secret trust is on the balance of probabilities. And therefore, in this case, the elements required to establish a secret trust were not met based on the evidence because Sophie did not clearly intend to create a legally binding trust for the family. And that shall conclude my presentation. Thank you very much.